Jesus is the answer for the world today. Above him there's no other, 'cause Jesus is the way.
Today we're going to be talking about confidentiality and HIPAA requirements. Now we're going to take a look at all this, but I want you to see it as an overall picture. First, what does the Bible say about these areas? Let me read you a couple of verses to start with. Leviticus 19:16. Thou shalt not go up or down as a talebearer among thy people, neither shalt thou stand against the blood of thy neighbor. I am the Lord. Proverbs 11:13. A talebearer revealeth secrets, but he that is of a faithful spirit concealeth a matter. Proverbs 18:8. The words of a talebearer are as wounds. They go down into the innermost part of the belly. Proverbs 26:20. Where no wood is, there the fire goeth out. So where there is no talebearer, the strife ceases. So what's the Bible saying? The Bible is saying that we shouldn't be going around telling stuff about other people. But this goes back way to ancient times. How many of you ever heard of the Hippocratic Oath? The beginning of medicine. Listen to this part of the Hippocratic Oath. Wherever in connection with my profession or not in connection with it, I may see or hear in the lives of men that ought not to be spoken abroad, I will not divulge as reckoning that which should be kept secret. So we have a basic whole idea from God, from the medical profession, saying that people should not be going around talking about stuff that is private to other people. And that's sort of a basis. And so today we're going to take a look at first Kansas law, then constitutional law, and then U.S. government law concerning these kind of areas. And what I'd like you to do is I'd like you to really do some thinking and sort it out so you can get the big picture here. But we have a moral obligation to protect the people that we're working with and to protect their information. So let's start with the Kansas law. And part of this we had last time. This is the law concerning what they consider to be unprofessional conduct. Failing to inform each client, student, or supervisee of the limits of client confidentiality, the purpose for which the information is obtained, and the manner in which the information may be used. Revealing information, a confidence, a secret of any client, or failing to protect the confidences, secrets, or information contained in a client's record, except when at least one of these conditions is met. We need to listen to this. We'll get into this deeper in a little bit, but I want you to hear this list. This is Kansas state law. Disclosure is required as permitted by law. Failure to disclose the information presents a clear and present danger to the health and safety of an individual or the public. The licensee or applicant is party to a civil, criminal, or disciplinary investigation or action arising from the practice of marriage and family therapy, in which case disclosure is limited to that action. The criteria provided in Kansas State Law 65-6410, and we'll look at that in a little bit. And amendments thereto are met, failing to obtain written informed consent from each client or the client's legal representative or representatives before performing any of these actions. All of these things you have to have permission for. Electronically recording sessions of that client. Permitting a third-party observation of their activities, or releasing information concerning a client to a third person except as permitted by law, failing to protect the confidences of, secrets of, or information concerning other persons when providing a client with access to the client's records. And lastly, failing to exercise due diligence in protecting the information regarding the confidences and secrets of the client with disclosure by other persons in one's work or practice setting. And I want to emphasize due diligence, because what does that mean? And a lot of the rest of the stuff we'll be talking about today is going to help you understand what they think due diligence is. Because you might think, well, no problem. You know, I leave stuff laying all over my office and no one should come to my office, right? They may not consider that due diligence. So what are we dealing with here? First, let's talk about confidentiality. Do you realize that you ought to keep confidence even if a person just comes to see you, or if they even call you, or if you schedule them? We're going to see that particularly in the drug alcohol law, because how many people don't want other people to know that maybe they're getting drug alcohol treatment? How about telephone conversations? See, these records may be maintained in a variety of media if reasonable steps are taken to maintain confidentiality, accessibility, and durability. Wait, hear those words again. Confidentiality, accessibility, and durability. And we're going to find out later, and we're going to be talking about the HIPAA law, which is the Health Insurance Portability and Accountability Act of 1996, federal legislation, that they're going to define what is reasonable and appropriate administrative safeguards, physical safeguards, and technical safeguards as set forth in that particular act. So even if you find out later you don't have to come under that act, could those same ideas be applied to you? Because yes, the Kansas law says you need to protect the data. It doesn't say specifically what you have to do. So here is a federal law that now says exactly what you have to do. So we want to listen to those things even if we might not come under that federal law, as we'll see here in the future. Each record shall be completed in a timely manner and shall include the following information for each client and client system. And we covered that again last time. Adequate identifying data. Data or dates of service that the licensee or the licensee's supervisee provided. The type or types of service provided. The initial assessment, conclusions, and recommendations. A plan for service delivery or case disposition. Clinical notes for each session. Sufficient detail to permit planning for continuity that will enable another marriage and family therapist or clinical marriage and family therapist to take over delivery of services. Now, where did this all come from? How many of you have ever heard of Tarasoff? If you've never heard of Tarasoff, you're missing out. Now, this was a particular case at the University of California at Los Angeles that set the tone for much of the law on confidentiality and much of the law of when you break confidentiality, and it has been applied in Kansas, which means this applies to you. And the story was this. There was a psychologist at the University of California at Los Angeles in their counseling center, and he had a client from India. And this client was dating a young lady whose last name was Tarasoff, and she was from South America, and she decided to break off the relationship. Well, how do you think the man from India saw this? Rules are a lot different there. He saw it as an absolute slap in the face and decided to kill her. Or at least that's what the psychologist thought. So the psychologist took him to the security police, to the security of UCLA, and said, I believe this man is going to try to kill his girlfriend. You need to do something with him. The police decided they didn't really totally agree with this, so they took him to another psychologist who determined that he didn't think that was going to happen. They released him, and he killed the girl. And so they sued the first psychologist, UCLA, the second psychologist, and they won completely. And this is what the court said, that in spite of confidentiality, the counselor has an obligation to prevent homicide, to warn the victim of homicide, to prevent suicide, and to report child or elder abuse. And so those are the basic rules that we go for. And as we look through the laws today more, we're going to find out there are quite a few other things that come under health care that you don't have to have releases for. So that means in your counseling, if you have someone that is suicidal, what do you need to do? Evaluate that, and if you believe they are, you need to take measures to prevent that. Take them to the nearest emergency room to get them help. If you have someone that is possibly going to be homicidal, I had a case of a situation where a lady was in the session was going to tell her husband she was having an affair with a neighbor. And she wasn't sure that her husband would not go over there and take this guy out. So what do I have to do? Call the neighbor. So I just want to warn you, you're going to be exposed in session tomorrow, and I can't guarantee you that this guy isn't going to come after you. I said, don't worry about it, I got a gun. But I had to warn him. And then we had to deal with that in session. You also know that you do have to report child abuse. You have to report elder abuse. Those are all requirements by state law. And so all of those things are the beginning of this picture. But we need to go into this picture a whole lot deeper because there are a lot of questions that are going to come up that you're going to be asking about this as to, well, how about this situation? How about that situation? And the good news is the law does cover a lot of those situations now, so we can understand exactly when we break confidentiality and when we don't break confidentiality in all the stuff that we're doing here. Another term you need to learn is the difference between confidentiality and privileged communication. In the state of Kansas, there are a lot of people with privileged communication. Doctors have privileged communication. Optometrists have privileged communication. Pharmacists have privileged communication. Licensed counselors, licensed psychologists have privileged communication. Who doesn't have privileged communication? You, if you're not licensed. Now, what does that mean? It means they can't take you into court and make you testify. There was another case like this that was very interesting because this particular person was getting his state license. But he had not been awarded his state license yet, and his client told him that he had committed a crime. And they called him to testify. What do you think happened? He had to testify because he had not been licensed by the state yet. Which means that you don't have privileged communication if you are a Christian counselor and you are not legally under the state. And you probably ought to let your clients know that. Because where's that going to come up? Probably in child custody suits and all sorts of other things. But see, it turns out that privileged communication, we're going to see in a little bit, doesn't cover child custody cases. There are a bunch of other exclusions that you maybe don't know about that you need to know about of what is actually covered and what is not covered. In drug and alcohol, commitment in the courts or facilities, except as necessary for treatment, court cases, studies if the name is deleted, is a Class C misdemeanor. That means that if you let somebody know that somebody else is enrolled in your drug alcohol program and you release that information, you could spend 1 month in jail and have a fine. Authorization is not required for insurance functions, disease functions, utilization reviews, fraud investigations, scientific investigations, medical or public policy research. There's a whole other area over here in which, again, confidentiality does not apply. But in most of those cases, they'll delete the names and do other things like that. Here's another very important one. Reporting of HIV, AIDS, and contagious diseases can be reported to the state for a medical emergency or people in contact. Do you understand? If you have a medical emergency, somebody has AIDS, you've got to tell, or the doctor has to tell all of those people that were in contact with those fluids that they may get AIDS and need to be tested for that. A physician may inform the spouse or partner. That partner can't tell other people that their husband or wife has AIDS. The person that reports it is exempt from criminal and civil liability. But if you violate that, it's 6 months in jail or $500 to $1,000 fine. That means if the doctor tells the wife and the wife starts telling other people, she could go to jail for 6 months. But what does that say to us? Because sometimes we get in those situations, especially dealing in drug alcohol. We have somebody that has AIDS, and let's say you know they have a partner, and the law says not just wife, it also says partner, that they have a partner and their partner doesn't know. Well, it says the doctor is allowed to tell the partner or the wife. So what I would do is I would go to the doctor and say, you know, I want to let you know this person is sleeping with this other person. I think they might be infecting them. I'd appreciate if you would notify the person. So that'd be a way of going around it, because the law doesn't say specifically counselors can do that. It says the physician can. All healthcare information is exempt from the Open Records Act. That means people can't just go and put some sort of a request for state records and they have to give them to you. And remember I told you in the last one, another exemption is Kansas Law 65-6410? We're going to look at that now for a little bit, because it is now going to tie down all of those things from Tarasoff into legal code. This is what that regulation says. It's called the Limits on Disclosure of Information in Kansas state law. A person licensed, remember I'm using marriage and family law, it would be the same under the other counseling laws. A person licensed under the Marriage and Family Therapist Licensure Act and employees and professional associates of the person shall not be required to disclose any information that the person, employee, or associate may have acquired in rendering marriage and family therapy services unless. That's interesting from a legal point of view. Because what did it say? It means your administrator. See, they could say, well, the counselor can't divulge it, but we'll make the administrator divulge it. No, anyone that's associated with it should not be divulging, unless disclosure is required by other state laws. And these are the laws then. Failure to disclose the information presents a clear present danger to the health and safety of an individual. What's that? That's the homicide, the suicide, and the warning the other person. See, there's Tarasoff. A person, employee, or associated is a party defendant to a civil, criminal, disciplinary action arising from the therapy, in which case a waiver of the privilege according to this section is limited to that action. Which means if somebody, says, sues you for malpractice, you can't say, well, you can't see the records, we have no release for those records. The client is a defendant in a criminal proceeding, and the use of privilege would violate the defendant's rights to a compulsory process or the right to present testimony or witness in that person's behalf. Notice it's in the person's behalf. A client agrees to a waiver of privilege according to this section, and in circumstances where more than one person in the family is receiving therapy, each such family member agrees to a waiver. Absence of a waiver from each family member, marriage and family therapist shall not disclose information received from a family member. That means that if you have two people sitting there and one of them gives you a release, you still can't release it. Every single person has to give you a release. If you were doing a group setting Every single person in that group has to give you a release to be able to release that information. Nothing in this section or in this act shall be construed to prohibit any person licensed under a Marriage and Family License Act from testifying in court concerning matters of, now listen to this, adult abuse, adoption, child abuse, child neglect, or other matters pertaining to the welfare of children. So therefore, in child custody suits, does privileged communication exist? No. Or from seeking collaboration or consultation with professional colleagues or administrative supervisors or both on the behalf of the client. There is no privilege under this section for information which is required to be reported to a public official. In other words, child or elder abuse. So do you see the picture of what we can't release and what we can release under Kansas state law? What is the information that you have to gather in order to get a release of information? According to law, you have to have the identity of the client, what information is released, to whom it is to be released, how the information will be used, the length of time up to 24 months. Now that's very interesting. The release can't last longer than 2 years. And a notice to the consumer that they may revoke their release at any time. I believe we have that all in the forms that we use here. Now here's another interesting thing, and this comes from constitutional law. And this is called TPO. You got to write that down. And TPO stands for Treatment, Payment, and Operations. And what that says is that in healthcare, you can use any information that you're given confidentially for treatment, for payment purposes, or for operational purposes without getting a release within your organization. Do you see? So therefore, you don't have to have a release for everything. One particular insurance company, we were really confused for a while because with some clients, when they would ask for the client's records, they would get a release from the client and send it to us. And other ones, they wouldn't. So they really didn't know themselves what they had to do or what they didn't have to do. But in this case, because it is TPO, it is within the operations of the insurance company, they didn't have to have a release. So that means you don't need a release to go and talk to your supervisor. You don't need a release to bill them for payment. You don't need to have a release or what you're going to do in the area of treatment all the time. Otherwise, you'd be totally hampered, wouldn't you? What do you not have to release? We'll get into this a little bit deeper when we get to HIPAA, but I just want to point out a few things. The things you don't have to release are psychotherapy notes. If you believe those psychotherapy notes are going to be detrimental to the client. In order to not release them, they have to be stored separately from your regular health records. You don't have to release information for litigation, and you don't have to release information that would be a danger to the patient. So those are exclusions, and they're exclusions just for therapy. Security. What security do you have to provide? Or should you provide? Well, how about voice security? We talk, don't we? So what's the security? Keep your mouth shut. Soundproofing. Who you talk to. What you talk about. What information you release in your talking. When you're talking on the phone. A number of things are sort of considered secure. Like you're okay to talk about things to a client on the phone. And that's supposed to be secure. Is it really? See, everything has to be within a reasonable level. How about sending a fax? How secure is that? More than that, how about emails on the internet? See, that isn't secure at all. So you've got to look at each method in which you are talking or sending information, and you're going to have to determine if this is really secure. As an example, when we do notes over the internet and do supervision that way, we make sure that there's no identifying information on those notes, because we don't believe that emails are really secure. But if there's no identifying information, then that's not a problem. How about written paper? How secure is that? Not secure at all if somebody else gets a hold of it, so you therefore have to protect it and lock it up, and under HIPAA we're going to find some very clear requirements of what that is, and you need to shred it. You need to keep it. You need to have a lock system. One of the biggest HIPAA lawsuits that we're going to see was over a company, when they were looking at them, had dumped their medical records in the dumpster. How secure is that? In fact, there was just a recent one I just heard of a abortionist in Kansas City that they're suing now. He already lost his license, but they found out that he had dumped all of his abortion records in a dumpster because he didn't want to pollute the environment. And my guess is they're going to try to apply the HIPAA law in that particular case. Electronic storage. Some people don't realize this, but it's a lot more insecure than you think. A lot of copiers do what when they make a copy? Copy an image. I have another lawsuit in which the person got rid of their copier, and all the medical records were on the copier. Hard drives. If you delete stuff off a hard drive, is it deleted? Not at all. So it has to be degaussed. When I was in the Air Force, if we had anything that we were being destroyed, like computers or anything like that, they had to run a particular program that wrote over all the data on the hard drive 3 times with random numbers. And the computer could be given some other organization that did not have your same security clearance. There's a lot of stuff out there. How secure do you think a flash drive is? Some flash drives, you can put a security code on them or something. They're a whole lot better. If you're walking around with a flash drive in your pocket and you lose it, what have you just done? Disks. What even goes further than that, what if somebody steals your computer? That's transmitting data. Maybe not your choice to transmit data. You just transmitted all of your files to somebody else, didn't you? So there are a lot of questions that come up when we deal with these particular areas, and I said when we get into the HIPAA regulation, we're going to tie that down a lot more of what you have to do and what you don't have to do. How about if you keep all your records in your office, right? And the place burns down. How secure is that? I'm not talking about release. I'm talking about you also have a requirement to be able to reproduce those records. So if you don't keep another copy someplace else of your records periodically, and there's a catastrophe, you still have a responsibility for those records. What if they're stolen from your office? How about software failure? We actually had a situation of some software we were using, and some records disappeared. We were doing backups on flash drives and so on and so forth, so we were able to recover some of those, but that showed us that our system wasn't very foolproof, was it? We still don't know what went wrong with the software. How about unencrypted databases? We were using some software a while back, and my son was home, and he's a computer engineer. And he took a look at the database, and he could recover the data on the database, on the computer. We had to decide that that software wasn't very secure. We now use a different type of software. But all of those kind of things. How about iPads? How about iPhones? Is your data that you're all downloading there encrypted? Next week, we're going to be looking at the different software, and we're going to find out there are two options for your software. There's one type you have on your computer in your office. There's another type in the cloud in which you keep all of your data from your health records on the internet in somebody else's computer someplace. Could that be a problem? You see the kind of things that there are in this whole question, especially when we get to electronic stuff, of all of a sudden the problems and the possibilities for compromise grow and grow and grow. So now let's take a look at HIPAA, the Health Insurance Portability and Accounting Act of 1996. If you want to learn more about it, go to www.cms.gov. Now, why did they do this on the federal level? Well, in a congressional hearing, they had 50,000 complaints of confidentiality violations. And they're hearing about all sorts of things. I'll give you an example. How easy do you think it would be to do identity theft if you had access to medical records? All the information is just laid out there, isn't it? In one particular case, somebody released the names of 4,000 people with HIV to 2 newspapers. Another case, when a congressman was running for Congress, somebody released the fact that he'd had depression and attempted suicide just before the election date. In a worse case, a rapist somehow got into the medical records of a hospital, and that's where he was getting the kids to rape. And of course, there's a need for medical records in an emergency, about like 9/11. You have people that are hurting and so on, and you don't have their medical records. How are you going to get them? So because of all that, they came up with this new law to try and deal with these issues. Now, a lot of the information I'm giving you from this law is from a seminar on HIPAA that I took from Joseph Borich III from Leawood, Kansas. But I have to tell you, I am not a lawyer, so this is not legal advice. And I recommend, especially if you're watching these videos from a different state, that you need to check into the laws of your state because they might be different than the laws of Kansas. What's the purpose and the requirement? If your healthcare organization transmits health information in one of the HIPAA transactions in an electronic format, you must maintain, now listen to this, reasonable and appropriate administrative safeguards, physical safeguards, and technical safeguards as set forth in this act. But see, those words are very close to the same ones that were said in Kansas, weren't they? So they're going to define now exactly what that means. So here are your 3 tests, and this is very important that you sort this out to determine whether you have to apply HIPAA before the law in your organization. I know at least of one other counseling center here in Wichita that does apply HIPAA and does do electronic submitting of their medical records for insurance. But here are the requirements. Here are the tests. Are you a listed entity? Entities are providers, insurance plans, public health, an insurer, a school, or a clearinghouse. That applies to all of us, doesn't it? Because we're at least a provider. So you have to say yes to test 1. Test 2. Are you creating and receiving health information that relates to the past, present, or future physical or mental health or condition of an individual, the provision of health care to an individual, to the past, present, or future payment for the provision of health care to an individual? Would we qualify for that? Yes, because you're producing health care information when you produce your notes, aren't you? And you're legally required to produce those notes. But the third one says this: if you are transmitting this health information electronically in a HIPAA transaction, you shall maintain reasonable and appropriate administrative, technical, or physical safeguards to ensure the integrity and confidentiality of the information, to protect against threats of security and integrity and unauthorized disclosure, ensure compliance by officers or employees. Now, one of the good things here is that mail, phone, and fax are not considered electronic transmissions because there's no change occurring between the time it's transmitted and what's received on the other side. So you think of teletype. See, you're sending one message, you're getting the same message. In fax, you're getting the same thing. In phone, you're getting the same thing. So that's not defined as electronic transmission. Now, what are the transactions? And this will tie it down for even further. What are HIPAA transactions? Their claims, their enrollment in a health plan, their eligibility, payment or remittance advice, premiums payments, report of injury, claim status, referral, certification, and authorization. So basically, the HIPAA transactions are all the stuff you do when you are making health care claims and receiving information from an insurance company. So that means if you hold them technically to exactly what it said, that a lot of other stuff isn't considered to be a HIPAA transaction, and therefore it wouldn't apply to that. As long as you don't want to do anything electronically via computer to a healthcare organization and are willing to stay in the dark ages of telephone, fax, and mail, you don't have to come under the HIPAA law because you're not transmitting electronically. That's the way I read it. You'll have to read it for yourself since I'm not giving you legal advice, right? But even if you choose not to transmit and therefore stay out of HIPAA, remember, we still have to be reasonably inappropriate safeguards to require the confidentiality, security, and safety of this data. And my concern is this: since they've now defined what those words mean, we need to do our very best to do the very best job we can to protect our healthcare data. I already mentioned to you the idea about copy memories and hard drives. How about a computer network? How well is your computer network protected that you're operating in? Protection of paper records. Under HIPAA, they have what's called the triple lock system. The requirement is your healthcare records must be kept in at least a locked filing cabinet, inside a locked room, inside of a locked building, which goes quite a bit beyond maybe what a lot of people are doing, which, keep them, they have a locked file cabinet, but that's about it. But that is the HIPAA requirement. Enforcement. What's been done here if you are under HIPAA and you violate the HIPAA regulations? Since 2009, there were 25,000 complaints. Of those, they didn't prosecute any of them. They just fixed them because the process is just getting going. But they were primarily for information that was wrongly revealed, poor protection, releasing more than was required, proper authorization not obtained, or the patients could not get their records. There can also be civil suits. I'll give you the biggest civil suit that there has ever been. In this particular nursing home, a patient died, and they were sued, and they were found to be hiding their medical records, and the jury awarded them $312 million, primarily as punishment for trying to hide their medical records. Civil penalties can range from $100 to $15 million. In the case where the paper records were in the dumpster, the company was charged $2.25 million. Criminal penalties. If you willingly disclose data, it could be $50,000 in 1 year in prison. Obtained under false pretenses, $100,000 in 5 years in prison. Intent to sell or transfer or use, $25,000 or 10 years in prison. So you see the picture, and you see that they're now putting teeth in this, and there's some pretty hefty penalties, primarily for what? To stop identity theft, to stop people from actually going directly against this, but there are still penalties if you don't do what you're supposed to do. So now let's talk about what you're supposed to do. And under HIPAA, there are 18 different areas called the Final Security Regulations. And on those regulations, you're going to find two things, if you decide to look them up. They're either going to have an R following the line, which means it's required of everybody, or an A following the line, which is required of large corporations and large companies. So let's go over those, and I'm going to explain to you what it does take to put HIPAA together. Then we'll look at the steps if you choose to decide to do that. Realize something, though, that in the future, if you are a licensed counselor and you are using insurance companies, those insurance companies could simply say, from now on, we will only accept electronic records. And if that happens, you immediately come under HIPAA, don't you? Or, if, as the U.S. government is trying to do, say everyone should be on electronic medical records by the year 2015, you might be forced to come under that particular law, because you then would have to make your medical records electronic. So here are the requirements. The first thing you have to do, risk management. You have to do a risk analysis. Conduct an accurate and thorough assessment of the risk to your data. Then you have to implement security measures to reduce those risks to a reasonable level. And the term here is reasonable. They're not saying you've got to spend $1 million on your HIPAA, even if you're a small little company. But you do have to do what is reasonable. The next is you have to have a sanction policy. If there are people working for you that violate the HIPAA regulations, you have to take sanctions. And then there's an information system activity review. You have to have regular reviews of the logs, reports, and security incidents that might occur in your company. That's all under security management. You have to assign someone security responsibilities. Identify a security and a privacy officer. Those are two different people, but they can be the same one, to deal with your security and privacy issues. Information access management. You have to work with the clearinghouse to identify who has access to the data and make sure that that access in all cases is taken care of. Security incident procedure. Response and reporting. How do you respond if something does get released? You must notify each individual whose information has been breached by first-class mail within 3 days. You have to maintain a running log of all breaches that affect less than 500 people. You have to notify the media outlets if 500 or more people, their security has been breached. And by the way, faxing a chart to the wrong place would be a breach of security, wouldn't it? Contingency plan. You have to have a backup plan to maintain an exact copy of your data. Disaster recovery plan. You have to have a plan to make sure even in a disaster, even if a tornado went all the way through the church and totally destroyed it, you could still replace the healthcare records. Emergency mode operation. And even after a disaster, you could bring your company back up to speed and be able to operate within a certain number of days. Evaluation. Periodically evaluate your system. I believe the requirement is at least once a year you have to do a total new evaluation. Business associate contract. The problem is, let's say you have somebody else you're associated with, and as part of that, say they do your administration for you. You have to have a separate contract with them to be able to guarantee that they are also maintaining HIPAA requirements. Physical safeguards, workstation use. You have to have a procedure when using a computer to safeguard the information. Workstation security, restrict access to the information. See, as an example, if you're using a password, you shouldn't be just taking this password and using it, turning your computer on and walking off and letting the computer operate with that password. Device and media controls. That you dispose of media in a correct way by degaussing it, by overwriting it, those kind of issues. If you get rid of a copier, if you get rid of a computer, that you do it properly. Technical safeguards. Access control. Unique user identification only to authorized personnel, and you track the user activity. Emergency access procedure. Others can gain access in an emergency. So if the person dies or is sick, it has the code some way, you have a way of getting the code so you can get to your healthcare information for your clients. Audit controls. You maintain a record and maintain activity. Personal and entity authentication. Verify that they're authorized personnel. How many large businesses have badges that people wear, and so on and so forth. Integrity. What virus protection do you have? Especially if you have access to the internet. What protection do you have that you don't get hacked? And transmission security. What rules do you have to make sure that everything is transmitted, doesn't get lost, and if it gets lost, how you can find it and work through all of the rest of those kind of things. So those are the things that even a small organization has to put together to meet the requirements of HIPAA. But I want to dig deeper into HIPAA now for some other areas, and then we're going to go and look at what you would have to do that. HIPAA release of information. One thing that's very interesting to me when they're doing all this work to protect everything, that HIPAA actually has less controls for some of the information. They allow it to be released without an authorization to more people probably than some of the other state laws do. You may release, it doesn't say you have to release, information without consent under HIPAA. Used for healthcare activities, abuse, neglect, and domestic violence. I've never heard anything under the area of domestic violence in any of the rest of the laws. Health oversight, judicial and administration oversight and procedures for law enforcement purposes. So it's some very interesting things in this HIPAA law about additional releases that might be able to work under HIPAA. Here's another very interesting one. After the person dies, for research purposes, overt serious threat to health or safety, and specialized government functions, whatever those might be. Standards for release of information. Here are some things that you really need to listen to because they're going to affect what you do, and they're not just under HIPAA. Who owns the medical records? The provider does. But the patient or patients can inspect and can copy the medical records. They can be refused, as I said before, for psychotherapy notes kept separately from the rest of the record if you feel or can demonstrate that this could damage or hurt the client. You must keep a record of the non-routine disclosures. So everything you disclose, if you don't have an authorization, you have to keep a record that you made that disclosure. The guardian can get the medical records up to age 18, but not afterwards. This is very interesting. So when the kid is 17 years old, the parents can have access to those medical records. Could that be a problem if you have given confidentiality to that teenager? What's interesting, though, when the kid is now 18 years old and one day, the parents can no longer access their medical records. They can access the medical records and ask that they be amended or corrected. Doctors can release information to families that they believe the client would want the family to have. Many times they'll say, because of HIPAA, we can't tell you anything like at the hospital. Well, there is the possibility that they can go beyond that if they need to. You're to release the minimum or least amount and refuse an authorization if it's not specific, it's past the date, or not filled out correctly or completely, or has false information. So it's saying you have a lot of latitude here. If you have a release of information, you really don't want to release it, you can make it pretty hard on them to be able to get you to release the information. But eventually you're probably going to really have to. They can restrict the use of the medical information even more than it's restricted by law. They can file a complaint, and they can ask for an alternate channel of communication. They can ask to give them the information over the telephone or over a fax or other types of ways of communicating. It doesn't have to be just come in and see that particular record. Remember, we said that business associates have to have a contract. How long do you have to maintain a medical record? According to HIPAA, it is 6 years after the end of the last session with the client, after termination. Or, if the person was a child, it is 2 years after they turn 18 or 6 years after you ended counseling, whichever is longer. Federal law states 5 years. Kansas law says that a hospital has to maintain records for 10 years, and Medicaid says 5 years. So for our purposes, the 6 years is probably pretty safe. There's a new thing that just came out I want to help you understand if you hear about it, and it's the new HIPAA version 5010. And all that did is change the electronic formatting. It really has no effect on you. There also was a change in the prescription drug standards and a change in the pharmacies. So it doesn't really affect you as a client, the new requirements under HIPAA. It's been a big thing in the last couple of years. It's now required that all electronic formatting has changed within HIPAA. Statute of limitations for malpractice in Kansas. 2 years after the session, except for delayed discovery. So that's one of the catches. In other words, somebody can't sue you for malpractice if it's over 2 years since the last session unless they can prove that they didn't know they were injured by it. And then there is no limit to how long you can be sued for malpractice, if they can say for some particular reason. Of course, what they're talking about here usually is they didn't find out that the doctor left the scissors inside of him until 5 years later and they got stabbed by it or something. So that's the way that particular thing works. HIPAA implementation. There's a 50-step checklist. I'm not going to go through this entire checklist, but basically I'll just read you a few of the points. Appoint a team, appoint a privacy and security officer, make a draft overall security policy, come up with your ways you're going to fix everything, implement everything, get forms for everything, make everything basically function in your company. But that's normally 50 steps. Forms. In this particular seminar I went to, they gave us 28 forms for all of the different things that you can do to cover every one of those little regulations, everything like they want to change the record. So they'll have a form that says application to change record, application to deny change of record, application to... So they basically have to have a form for all of these different things that you're doing. But now let's discuss the issues before we close here today. And so to put this together, okay, what are the pros and cons of getting involved in HIPAA or opting out of HIPAA by simply not using electronic transmission? Well, the pro is you don't have all the legal work, and you maybe aren't as technically required to dot every I and cross every T and do everything as they require you to do it. But eventually you might have to. And of course it wouldn't hurt you from the standpoint that you'd be taking care of everything very well and very correctly, and you'd be very well covered. But of course, you would also come under the regulation, then it could be sued under that regulation. It could be applied to you. If you're going to do it, you probably need a lawyer. Someone to at least check it out, pay somebody. The particular lawyer that the seminar I was at offered to do that for a sum of money, fairly significant, to look through your company and make sure you're all in compliance. Make sure you're doing everything right. Good things I'm going to recommend here: keep a record of any releases, because that's required. People are going to expect that, aren't they? Security records. Do the very best you can. I would go to triple lock if you possibly can. That might be very difficult to do, especially in some churches, of where you're going to put your medical records, and especially the ones that are archived, to make sure that those are totally protected. If you have your records on a flash drive, I would encrypt it. I would suggest you need to lock an extra copy someplace and maybe copy it weekly and put it someplace else in case your computer gets stolen or something else happens, or your records get stolen. Medical records, separate them from your notes. So if you have a situation that you feel it is not good for the client to release the medical records, you can hold on to those records and not release them. Future prospects. Are you thinking about taking insurance in the future? You may want to think about implementing HIPAA, or at least doing more of these kind of things. But finally, would you agree with me that we have a moral obligation, even if you avoid some of the technical laws and the technical rules, that you still have a moral obligation to do the best job you can to protect your medical records, make sure there are not disclosures, and not just fly by the seat of your pants? So what's my recommendation? Perform a risk analysis, even if you're not doing HIPAA, and look around and figure out what's going on and make sure that you're doing the very best job you can that'll be honoring unto God and honoring unto people, and that people will not get hurt because of your negligence or because of things that you did not do. Unfortunately, there are a lot of things, even with the HIPAA regulation, that are really iffy. Like the emails, like if you have a computer and you're uploading all of your stuff from your phone, and your phone gets stolen, how protected is your phone? But your job is to do what's reasonable to the best of your ability to protect other people's information in this whole healthcare thing. I recommend you don't take it lightly. A couple lawsuits could really ruin your day and really shut things down. Let's pray. Lord God, I ask that you would help us. Lord, with us people, we tend to make more and more regulations, and we have all these intricacies. I ask that you would give us wisdom. I ask that you would help us. I ask that you would guide us. Help these people, Lord God, as maybe they start their own counseling center or improve the one they're dealing with, to understand these things, not be overwhelmed by them, but realize you have it all under control. And we give you the glory and the honor in Jesus' name. Amen.
Jesus is the answer for the world today. Above him there's no other, 'cause Jesus is the way. Jesus is the answer